With personal jurisdiction, we are asking, over whom may the court exercise its power? Hello, I'm Rick Faulkner from Chapman University School of Law, and this is Civil Procedure. We'll begin with federal civil procedure. We begin with the subjects that are by far the most tested topics on the California bar exam: jurisdiction and venue. It will be tremendously important for us to understand and discuss separately three distinct topics: personal jurisdiction, subject matter jurisdiction, and venue. Each of these issues relates to the question of whether the plaintiff has chosen the proper court in which to file his action. Not every bar exam essay that raises questions about the proper court will require you to discuss all three of these topics, but if the call of the question does not narrow the scope of your essay, you should be prepared to discuss all three. Since it is extremely important for us to understand the distinctions between these three topics, it will help at the outset to understand what each of them is determining. Personal jurisdiction addresses the question, does the court have the power to make rulings that affect a given individual, corporation, or piece of property? In other words, with personal jurisdiction, we are asking, over whom may the court exercise its power? With subject matter jurisdiction, the question is not who, but what. We are concerned with whether the subject of the litigation is a proper one for the court to consider. As an initial matter, keep in mind that this is only an issue for federal courts, because state courts are courts of general jurisdiction, while federal courts are courts of specific jurisdiction. This simply means that state courts are typically not bound to hear cases dealing only with certain subjects. They have the power to hear cases covering pretty much the entire range of causes of action. The exception to this is certain specialized state courts, such as probate courts, but for the most part this will not be relevant to us on the bar exam. For the bar exam, it is usually sufficient to note that in state court matters, a plaintiff will generally not be restricted from bringing an action due to the subject matter of the case. There may be specific state procedures for bringing cases, but there will be some state court available to hear the plaintiff's action. In federal court, the situation is completely different. As courts of specific jurisdiction, federal courts only have the power to hear specific enumerated types of cases. If the plaintiff's action does not fit into one of the enumerated cases the federal court can hear, the plaintiff will be unable to bring her action in federal court. Thus, for the bar exam, when the call of the question puts jurisdictional issues into play, we need to analyze federal actions to determine whether the plaintiff's action fits within the subject matter jurisdiction of federal court. The third related topic is venue. We have seen that personal jurisdiction is a question of whom. The relevant question is whether the court has power over a given defendant or property. Subject matter jurisdiction is a question of what. We are asking whether the lawsuit itself is a proper subject to be raised in federal court. With venue, the question is where. We are asking whether the court in which the plaintiff has brought his action is the proper place for the case to be litigated. Each of these three related subjects requires some in-depth understanding and analysis, so we will address each in turn. Personal jurisdiction. Recall that with personal jurisdiction, our basic question is whether the court has the power to make rulings affecting a given defendant. This is a relevant question for both state and federal courts because Rule 4 of the Federal Rules of Civil Procedure provides that a federal court must, in most cases, analyze personal jurisdiction as if it were a state court of the state in which the court is located. For example, an Oregon federal court must analyze personal jurisdiction as though it were an Oregon state court. Categories of personal jurisdiction. There are three different types of personal jurisdiction, each of which could come up on a bar exam essay. In personam jurisdiction, in rem jurisdiction, and quasi-in rem jurisdiction. The most common and most familiar type of personal jurisdiction is in personam jurisdiction. In personam jurisdiction exists when the court has the power to make rulings affecting a specific person or corporation. If the court has such power, it may make orders that directly affect the individual or corporation, and those orders would be entitled to full faith and credit in other states. Most of the following analysis deals with in personam jurisdiction, as it is the type of jurisdiction at issue in most real-life cases, as well as most bar exam fact patterns. The question of whether the court has power over a given defendant. However, it is important to understand the other two types as well. In rem jurisdiction exists when the court has the power to adjudicate the rights of all persons, whether subject to in personam jurisdiction or not, with respect to a given item of property. The rule here is that the property must be located within the state, and it cannot have been brought into the state by force or fraud. Each state will have a series of statutes that provide for various in rem actions. For instance, in an eminent domain case, a state can exercise in rem jurisdiction over the real property to be condemned, regardless of whether it has personal jurisdiction over the individuals who are property owners. One can easily imagine a situation where someone owns property in state X, despite not living in state X, nor having any dealings with state X. Nevertheless, if state X wishes to condemn the property, it has in rem jurisdiction to do so because the property is found within state X. Similarly, when settling a decedent's estate, state X would have in rem jurisdiction to dispose of the property located within state X, regardless of whether it had in personam jurisdiction over the individuals whose property rights might be affected. This is not all that commonly tested, but just keep in mind that it can apply when dealing with property physically located within a state. The most common fact scenarios for in rem jurisdiction are condemnation actions, property forfeiture actions, and settlement of estates. The third category is quasi-in rem jurisdiction. There are two types of quasi-in rem jurisdiction. The first is when the court is deciding on an issue of ownership of property that is within the court's control. For example, if the issue is ownership of an automobile, and one of the parties attaches the automobile in state X to prevent its sale, the court would be exercising quasi-in rem jurisdiction when determining ownership as between plaintiff and defendant. The second type of quasi-in rem jurisdiction is when the court adjudicates a dispute other than ownership of property based upon the presence of defendant's property in the forum state. This is a bit trickier, so let's imagine an example. Plaintiff, a California resident, travels to Florida, gets into a car accident, and has a negligence claim against defendant for the auto accident that occurred in Florida. Defendant is a Florida resident, but owns a boat docked in California. If plaintiff attached the boat and attempted to sue in California using the presence of defendant's property to justify the lawsuit, that would be an exercise of quasi-in rem jurisdiction. There are a couple of things we need to understand about quasi-in rem jurisdiction. First, it is subject to the international shoe minimum contacts rules we will discuss in a moment. In other words, in the case I just described, if defendant had no connections with California other than the boat docked there, it would be highly unlikely that the court would conclude that she could be sued in California for a claim that has nothing to do with the existence of the boat in California. By contrast, if the ownership of the boat were at issue, as in the first type of quasi-in rem jurisdiction, its presence would likely be a close enough connection to permit the court to exercise jurisdiction. In addition, when the court exercises quasi-in rem jurisdiction, plaintiff's recovery is going to be limited to the property at issue. In other words, if plaintiff and defendant were litigating the ownership of the boat from the previous example, and the court was exercising quasi-in rem jurisdiction, it would be unable to make additional orders or awards affecting defendant beyond the ownership of the boat. The jurisdiction is limited to the property at issue. The main difference between in rem and quasi-in rem jurisdiction is that in rem jurisdiction affects all persons' rights in a given piece of property, while quasi-in rem only affects those individuals litigating before the court. Thus, if a court is settling an estate by determining who owns a boat that is part of the estate, that will affect everyone's rights in the boat, whether or not they are subject to jurisdiction in the state. On the other hand, if a court is determining ownership of a boat that has been attached by plaintiff, this exercise of quasi-in rem jurisdiction will only affect the rights of plaintiff and defendant, not absent parties or those over whom the court has no jurisdiction. Constitutional limits of personal jurisdiction. Next, we need to understand the constitutional limits of personal